When I know where that was before you went there? I walked around the building 3 times before I. Will the Senate please come to order? We'll take a moment of silence in lieu of a devotional this morning. Thank you. Will you please join me in the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Would the President Pro Tem like to confirm that we did the pledge this week? This morning we have S 324. Okay, so I just. Okay. Senator Collmore.
Thank you, Mr. President. Appearing on the calendar for notice, I move that S 324, an act relating to legislative operations and government accountability, be committed to the Committee on Government Operations.
The senator from Rutland has moved that S 324, an act related to legislative operations and government accountability, be referred to the Committee on Government Operations. Are you ready for the question? If so, all in favor say aye.
Aye.
All opposed, nay. Ayes have it. Motion carries. Senator from Washington.
Thank you, Mr. President. Appearing on the calendar for notice, I move S 325, an act relating to studying the creation of model bylaws, be committed to the Committee on Natural Resources and Energy.
Senator from Washington has moved that S 325, an act relating to studying the creation of model bylaws, is referred to the Committee on Natural Resources and Energy. Are you ready for the question? If so, all in favor say aye.
Aye.
All opposed, nay. Ayes have it, and the motion carries. Senator from Windsor.
Thank you. We seem to go numerically here. Appearing on the calendar for notice, I move that S 327, an act relating to economic development, be committed to your Senate Committee on Economic Development, Housing, and General Affairs.
The senator from Windsor has moved that S 327, an act relating to economic development, be referred to the Committee on Economic Development, Housing, and General Affairs. Are you ready for the question? If so, all in favor say aye.
Aye.
All opposed, nay. The ayes have it, and the motion carries. Senator from Lamoille.
I think the chair was a little out of order. Appearing on the calendar for notice, I move S 326, an act relating to the miscellaneous amendments to laws relating to motor vehicles, be committed to the Committee on Transportation.
The senator from Lamoille has moved that S 326, an act relating to miscellaneous amendments to laws relating to motor vehicles, be referred to the Committee on Transportation. Are you ready for the question? If so, all in favor say aye.
Aye.
All opposed, nay. Ayes have it, and the motion carries. Senator from Windsor.
Back into numerical order. Appearing on the calendar for notice, I move that S 328, an act relating to housing and common interest communities, be committed to the Senate Committee on Economic Development, Housing, and General Affairs.
The senator from Windsor moves that S-328, an act relating to housing and common interest communities, be referred to the Committee on Economic Development, Housing, and General Affairs. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and the motion carries. We now have a Senate resolution, SR 21, Senate Resolution to U.S. Immigration and Customs Enforcement Operations Metro Surge, offered by Senator Hashim and others. Listen to the first reading of the resolution.
SR 21, Senate Resolution relating to U.S. Immigration and Customs Enforcement's Operation Metro Surge.
Now you've heard the reading of the resolution, and it is referred to the Committee on Judiciary. JRS 39, Joint Resolution relating to weekend adjournment on February 6th of 2026, introduced by the Senator from Chittenden Central, Senator Baruth. Listen to the first reading.
Resolved by the Senate and House of Representatives that when the two houses adjourn on Friday, February 6, 2026, it be to meet again no later than Tuesday, February 10, 2026.
Now you've heard the reading of the resolution, and the question is, shall the Senate adopt the resolution on its part? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. Ayes have it. The motion carries. Orders of the day. We have appointments. Let's see. We have appointments reported out of committee to take up confirmation. This appointment is of Christina Nolan of Burlington as Associate Justice of the Vermont Supreme Court from and including January 5th, 2026 to and including March 31st, 2029. The question is, shall the appointment of Christina E. Nolan be confirmed by the Senate? Recognize the senator from Windham.
Thank you, Mr. President. We're voting today on the confirmations of Christina Nolan and Michael Drescher to fill two vacancies on the Vermont Supreme Court. These presentations will be broken up into a few different sections. As I've said in the past for challenging confirmations, this is all essentially a job interview. It's a long and at times uncomfortably awkward job interview, and we are the hiring committee. I'm going to share some important factors about this entire process as an introduction, and then for each nominee, I'll provide a general summary of their past work experience, followed by a more subjective presentation. So to begin, to the best of my knowledge, there hasn't been a time in our state's history in which the Senate simultaneously goes through the confirmation process of two Supreme Court justice nominees. These are lifetime appointments. The committee followed our standard procedure for these confirmations. It was a process that was developed to ensure the committee has enough time to do its due diligence, to allow the nominees plenty of opportunity to testify and respond to questions and testimony, and for the committee to form a conclusion. The few individuals who are granted the title of justice are individuals who will interpret state law and state constitutional questions. They will render opinions that will impact our judiciary and our state for many decades, if not centuries. State Supreme Courts deal with issues involving state law and the state constitution, although it is possible for federal laws and the U.S. Constitution to be interwoven in a case before the state Supreme Court. It's also possible for a state Supreme Court decision to be appealed to the U.S. Supreme Court. I want to discuss, for what is hopefully the first and last time on the floor today, the topic of party affiliation of the nominees. It was established at the beginning of this process that the committee will approach this in a nonpartisan manner. Our Supreme Court is a nonpartisan, apolitical body, and the confirmation process should mirror those same concepts. Our committee has received testimony, and I've received many emails and I've had conversations with a variety of folks in which assumptions or declarations of the individual nominee's political affiliation are made. Generally speaking, I've had people tell me that Ms. Nolan is a conservative and therefore shouldn't be confirmed, just as I've had people tell me that Mr. Drescher is a liberal or a conservative and should or shouldn't be confirmed. And ironically, in the same breath, many of these messages also say, don't bring politics or ideology into this. And I want to be clear that at no point have either nominee expressed to us their personal political views. To do so would violate the Code of Judicial Conduct. And I just want to reemphasize when I said that this is a nonpartisan, apolitical process, and of course I can't tell anybody how to weigh their decision-making process, but I would respectfully ask that senators do not provide weight to their assumptions that they might have about a nominee's personal political affiliation. I also want to note that there were certain questions that the nominees were unable to answer. Although they are nominees, they are still bound by the Code of Judicial Conduct, and depending on the type or manner of certain questions that were asked, they may have felt prohibited from answering during the hearings. So if you heard them avoid a certain question and cite the Code of Judicial Conduct, similar to the political affiliation, I would request respectfully that you not hold that against them. Before I begin with Ms. Nolan, there's just a short quote that I've kept in mind throughout this process from current U.S. Justice Kagan. During her confirmation hearing, she stated, "The Supreme Court, of course, has the responsibility of ensuring that our government never oversteps its proper bounds or violates the rights of individuals." She was, of course, referring to the U.S. Supreme Court. However, the same concept applies here. So I'll now move on to Ms. Nolan. Ms. Nolan graduated from the University of Vermont and then the Boston College Law School. She's been a practicing attorney for a total of 21 years, with 15 of those years in Vermont. Immediately after law school, Ms. Nolan clerked for a federal judge in Massachusetts for a year and then moved on to a private law firm, also in Massachusetts. At this private firm, her primary practice areas were as a defense attorney and a civil litigator. After her time at the private firm, she moved on to a district attorney's office in Massachusetts from 2008 to 2010. After her time as a prosecutor in Massachusetts, she filled an assistant U.S. attorney role in Burlington, Vermont. She worked for 7 years in the criminal division until 2017. After the top position in the office became vacant, Ms. Nolan was interviewed by Governor Scott and then Senator Leahy. And among the list of candidates, Governor Scott and Senator Leahy sent Ms. Nolan's name up to be recommended as the U.S. Attorney for the District of Vermont. Ms. Nolan served in this capacity from 2017 to 2021. Notably, Ms. Nolan was the lead U.S. attorney on the Purdue Pharma lawsuit, which resulted in an $8 billion settlement. And Ms. Nolan, in a press conference, she stated that the business decided to put profits over people, even when so many folks were suffering from opioid addiction. Ms. Nolan described the last 10 years of her work as being split 50-50 between civil and criminal work. She's described participating in at least hundreds of evidentiary hearings and trials. She's personally tried at least a dozen cases to conclusion before a jury and has also had dozens of bench trials. She's handled numerous appeals as lead counsel and has represented clients in contested hearings in family court, including juvenile matters, probate matters, and administrative or regulatory hearings. After stepping down, Ms. Nolan began working at a private law firm in Burlington, Vermont, where she handles criminal defense and civil litigation. So that concludes the general summary of Ms. Nolan's resume and experience. It doesn't encompass every single detail and nuance of her past, but it does provide just a general picture of her work as an attorney. So now I'll pivot to my position on her confirmation. So to begin, I'll first admit that when I first saw Ms. Nolan's name at the beginning of the judicial nominating process, it gave me pause. That was my initial reaction, but only because I recognized her name from past public information. Now, the JNB process is largely confidential, so I won't speak to that process, but I will say that despite my initial hesitations, I was both pleasantly and positively surprised by her as a candidate and now as a nominee. As I do with all candidates and nominees, I put aside my initial reactions and approached the process with an open mind. Ms. Nolan possesses a breadth of experience, both as a private attorney doing defensive and plaintiff's work in state court, as well as a number of years as a federal government attorney. I believe this is a balanced amount of experience in different practice areas in courts. I know there were concerns raised about the fact that Ms. Nolan served a number of years as a prosecutor. However, being a prosecutor is not a disqualifying factor in any way. Prosecutors regularly have to deal with how their actions impact fundamental rights, and they must be keenly aware of how their discretion can impact an individual and their families. One piece of written testimony in particular struck me in this process. It was a letter from a person who was previously prosecuted by Ms. Nolan. His name is Justin Goulet. He was initially charged with trafficking and firearm offenses while he struggled with a serious opioid addiction. And after spending some time in jail and becoming sober, Mr. Goulet became friends with Ms. Nolan. They stayed in regular contact, and he repeatedly expressed gratitude for how he was treated by Ms. Nolan and how her actions helped contribute to his sobriety. What I saw in the multiple hearings we've had with Ms. Nolan and in my one-on-one conversations with her, she's a person who was just very human and very self-reflective and empathetic. She's also humble, and humble attorneys are hard to find. I'm fully confident that Ms. Nolan would serve as a justice with integrity. As she claimed, the Supreme Court must act as a bulwark against government overreach. I'm confident she'll maintain that perspective, and I have no reason to suspect otherwise. The vote in committee was 5-0-0 to positively recommend Ms. Nolan's confirmation to the Vermont Supreme Court, and I ask for the Senate's support.
The question is, shall the appointment of Christina E. Nolan as Associate Judge of the Vermont Supreme Court be confirmed by the Senate? Are you ready for the question? If so, all in favor? Senator from Addison.
I just wanted to make remarks, if that is okay. We're doing that, yes?
We're doing that.
Okay. As a member of the Judicial Retention Committee over the past 7 years, I have reviewed dozens of judicial applications and interviewed the vast majority of judges sitting in Vermont today. None of you will be surprised to hear that I relish the opportunity to ask judges tough questions, hold them accountable, and hear them reflect on how they could do their jobs better. I'm particularly focused on how judges craft an argument and reach a decision based on the evidence before them and the laws we write. How they show up with empathy and respect for Vermonters who work or appear in their courtroom, and how they recognize their own privilege and bias when presiding over a process that can determine the future paths of so many people. I dug into the task of assessing Christina Nolan and Mike Drescher in the same manner I've been judging judges for the past 7 years. There's never been a more important time to choose justices who truly live up to the title justice and who bring faith in our judiciary to the people of Vermont through their actions, experiences, decisions, and values. Now more than ever, we need a strong court that will uphold the Constitution, rule of law for everyone who finds themselves in Vermont. After a deep dive into her record, reviewing the testimony and conducting 2 interviews with her, I believe Christina Nolan will be a strong addition to the Supreme Court. While it's likely that I won't agree with all of her decisions, I believe that she has a curious and sharp legal mind and will deliver well-reasoned and well-written legal decisions, grounded in our laws and our Constitution. She has a diverse legal background that provides her with a foundation that many judges lack in both civil and criminal law and both prosecutor and defender perspectives. The fact that she would come to the court without previous experience on the bench would allow a perspective on a court that is otherwise filled with senior judges. Nolan's managerial experience at the U.S. Attorney's Office would also benefit a court that is tasked with overseeing the full judicial branch. At only 45 years old, Nolan is young for a Supreme Court justice, so she could have a generational impact on the legal system in Vermont. While some are concerned that she may swing the court to the right, I think rather that she'll keep the court grounded in admirable values. I found Nolan to have a strong moral compass and the ability to allow her beliefs to evolve. She's not afraid to admit she's wrong or doesn't know something. She knows when she's made a mistake and does the work to learn from it. She allows new evidence, research, and experiences to change her beliefs and perspectives over time. As a lesbian woman, Nolan has known the sting of discrimination and would bring this valuable perspective to the court. Her writing and work demonstrate a degree of empathy that is born out of personal experience and so desperately needed in our judicial system right now. When she talked about her clients and the people she's impacted as a prosecutor, she demonstrated a genuine care and concern for their welfare. One of her sample briefs highlighted a case about a man in Middlebury who she and his community have helped turn his life around. Finally, I was impressed by her awe of and dedication to public service and her strong desire to serve the state she loves. These characteristics will not only serve her well on the court, but will serve Vermonters well too. I firmly support Christina Nolan's nomination, and I hope you will join me in voting yes. Thank you, Mr. President.
Are you ready for the question?
Roll call.
Roll call has been called for, and when the vote is taken, it shall be by roll. Are you ready for the question? If so, the secretary shall call the roll.
Senator Baru.
Yes.
Senator Beck.
Yes.
Senator Benson.
Yes.
Senator Bonner.
Yes.
Senator Brennan.
Yes.
Senator Brock.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
No.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Gulick.
No.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hashim.
Yes.
Senator Heffernan.
Yay.
Senator Ingalls.
Yes.
Senator Lyons.
No.
Senator Major.
No.
Senator Matos.
Yes.
Senator Morley.
Yes.
Senator Norris.
Yes.
Senator Perschlick.
No.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Bohosky.
Yes.
Senator Watson.
No.
Senator Wheat.
Yes.
Senator Westman.
Yes.
Senator White.
No.
Senator Williams.
Yes.
The ayes voting 23, the nays voting 7. The ayes have it, and you have confirmed Christina Nolan as Associate Justice for the Vermont Supreme Court. We now have another appointment. This is the appointment of Michael P. Drescher of Heinsberg as Associate Justice for the Vermont Supreme Court for a term of and including January 5th, 2026 to and including March 31, 2029. The question is, shall the appointment of Michael P. Drescher be confirmed by the Senate? Senator from Windham.
Thank you, Mr. President. This presentation will be longer than the last one, I can tell you that. As with the last confirmation, I'm going to present a summary of Mr. Drescher's past experiences. Mr. Drescher graduated from Dartmouth College in 1987 and went to work for an advertising company in Chicago for several years until 1992. He went to law school at Northwestern University School of Law and graduated in 1995 in the top 10% of his class. After graduating, he was a law clerk in the Second Circuit until 1996. He then went on to work as an associate at a private law firm in Burlington from 1996 to 2000, and then as a partner at the same firm until 2002. From 2002 to 2026, Mr. Drescher was an attorney at the U.S. Attorney's Office in Burlington, covering the District of Vermont. Between 2002 and 2009, he was an assistant attorney in the Civil Division. From 2009 to 2023, he was an assistant attorney in the Criminal Division. From 2023 to 2025, he was the first assistant U.S. attorney, which is essentially the second in command in the office. From January 2025 to January 2026, Mr. Drescher was the acting U.S. attorney for the office, a position that he automatically filled due to a vacancy. He was not appointed by the president. One of the notable cases that Mr. Drescher was involved in was a case that I had mentioned for the previous nominee, This was the Purdue Pharma lawsuit, which resulted in an $8 billion settlement. Mr. Drescher and his colleague, Owen Foster, who at the time was also an assistant U.S. attorney, were directly given credit for discovering the illegal kickback schemes through their diligent work. Mr. Drescher described the last 10 years of his work as being focused 95% on criminal matters and 5% on civil matters. Since being in the U.S. Attorney's Office, Mr. Drescher has had one bench trial and at least 6 jury trials. He's participated in over 100 contested evidentiary hearings, detention hearings, suppression hearings, supervised release violation hearings, and sentencing hearings. In the past 10 years, he has been the lead attorney on about 10 appeals to the Second Circuit. During his time as assistant U.S. attorney, he's also worked on cases involving medical malpractice, environmental challenges to federal programs, and personal injury claims in the civil division. Much of Mr. Drescher's direct state court experience arises from his time in private practice prior to his employment at the U.S. Attorney's Office. However, it is important to note that state law is often litigated in federal court, but the court will use the federal rules of civil procedure. So that is the general summary of Mr. Drescher's resume and experience. And again, it does not encompass every single detail and nuance of his past, but does provide a general picture. So I'll start by saying that this has been the most difficult decision I've had to make here. It's been a significant pushing and pulling between what I understand as an attorney, admittedly a rather new attorney, but also compared to my philosophy for how I serve as a senator. There was one night a few weeks ago when I was deliberating with a friend of mine who also happens to be a lawyer. We were going back and forth about this confirmation and debating the different philosophical dilemmas. And after a while, my friend looked at me and he said, you know, sometimes I just hate being a lawyer. He was joking, more or less, I think. For me, the issue goes beyond the nuances of past experiences. And Mr. Drescher certainly does have a lot of experience and intellect. Rather, this all goes to the heart of the issues we're facing today as we continue to see draconian policies implemented by the federal government, a number of which people find to be either unconstitutional or directly contradictory to the norms we've established over decades in America. One of the primary issues surrounding Mr. Drescher's confirmation is that of his involvement in representing the government as it relates to the high-profile detentions of Ramesa Oster and Mosa Madawi. Now, I want to be clear that Mr. Drescher was not responsible for commencing the immigration proceedings, nor was he responsible for initially detaining either of these individuals last year. However, Mr. Drescher's role as the acting U.S. attorney was to serve as the respondent to these two individuals' petitions for a writ of habeas corpus. This petition essentially challenges the government's grounds for detention and seeks release for the petitioner. Mr. Drescher's role was defensive in nature. Prior to responding, Mr. Drescher was aware that these individuals had been detained as a form of retaliation for exercising their First Amendment right. Through the hearings and through reading the pleadings, I've come to a basic understanding of what happened. I understand why Mr. Drescher raised certain points, and I do not think that he acted in an unethical manner. However, at the end of the day, he did make arguments that were for the purpose of vindicating the unconstitutional detention of two individuals. And this is where a divergence in opinions arise. Some may argue he was doing his job and had no other options. They would argue that he had an ethical obligation to do his job, and as an apolitical government attorney, his representation of the U.S. government was not necessarily an endorsement of the government's policies. On the other hand, those who oppose his confirmation have argued that he did have other options, such as not opposing the petitioner's release from detention, or taking no position, or the extreme step of resigning altogether. They would argue that Mr. Drescher had an ethical obligation to refuse to defend the federal government in these circumstances. Mr. Drescher's response to these alternative options, and I'm summarizing, were that if he resigned, the responsibility would have fallen to someone else. Or if he stated the government had no position or did not oppose the release from detention, it could potentially be an ethical violation, or he could be fired. Some witnesses in favor of Mr. Drescher raised the point that we shouldn't let these two instances shroud his past decades of excellent work as a government attorney, and he has done excellent work in the past. One such positive reference, a former U.S. attorney and colleague of Mr. Drescher's, wrote that electoral changes mean policy changes, and that the policies are crafted by Washington. Mr. Drescher himself stated to our committee that the cases reflected an extraordinary change in executive policy, which was causing dramatic and unfortunate consequences across the country. And my response to that is, if we're not drawing the line now about extraordinary changes, which are causing dramatic and unfortunate consequences, when do we draw the line? When the resulting unfortunate circumstances are contrary to fundamental rights, at what point is the argument of, I was just doing my job, no longer acceptable? I do recognize that it's the status quo of government attorneys to do their jobs in an apolitical manner and throughout different administrations. But we do not live in the status quo right now. We're living through an administration that has thrown social and political norms into the trash, and each senator here is going to have to weigh as to whether you're willing to draw the line now or later or not at all. One argument that's been raised is that many concerned Vermonters simply don't understand federal immigration court procedure or have a misperception about Mr. Drescher. But I do think that message distracts from the real point shared by concerned Vermonters. I don't expect any of my constituents to create detailed legal memoranda that dissect the past pleadings filed by Mr. Drescher, nor do I expect them to read a 70-page Third Circuit Court of Appeals decision. I don't expect them to brief on whether the Immigration and Nationality Act strips a district court of its jurisdiction to hear habeas petitions before or after a final order. But I do expect them to share how they feel. And they have been correct in their general understanding that Mr. Drescher was involved in defending the federal government's actions. Those actions were adverse to fundamental rights. And any involvement at this point, regardless of how it's justified or rationalized, is the end of the road for anybody who wants to work in government. That's the message that I've received by an overwhelming margin. So, is that message wrong? Is it too harsh or premature? At what point are the people right, regardless of how a politician may feel? Starting with my own district, I've had two retired judges reach out to me, Judge Wesley and Judge Hayes, each with strong opinions that oppose Mr. Drescher's confirmation. These are judges I've known for probably going back to 2012, and in their own ways have shaped the respect and the perspective that I have for our judiciary. I've had attorneys from my county who many years ago cross-examined me and deposed me, and much more recently now serve as mentors. And they have reached out to express their opposition. And they too have helped shape my perspective and respect for the judiciary. And of course, I've had dozens upon dozens of constituents from Windham County express their opposition, as well as hundreds of Vermonters from across the state. And again, underlying it all is that same message I raised earlier regarding Mr. Drescher's confirmation. And so in this case, I have to ask myself, is it appropriate for me to look at all of those constituents I just described and say to them that they just don't understand, or that it's too complicated, and that I'm going to vote differently than how they're asking me? I don't think it's appropriate. Trust and confidence in government is eroding. It's been an ongoing issue for decades, but has deteriorated exponentially over the last few years. The social contract between the government and the governed is increasingly fragile, and voting contrary to the many voices of Vermonters would only further contribute to that fragility. So I'll be voting no on this confirmation. I'm going to try explaining the committee vote without sounding like we're on an episode of The Twilight Zone. The committee, by a vote of 3-0, recommends no recommendation. That's not a positive recommendation, nor is it a negative recommendation. As I've been informed, I can't present on the votes of individual senators or their intentions, only my own. And since the committee does not have a position, I cannot represent a committee position. I can say that I was one of the 2 no votes regarding the motion of sending this confirmation out with no recommendation, and that is because I believe, both as a chair and a senator, the committee is expected to provide guidance. We're especially expected to provide guidance, good or bad, in more complicated or controversial issues, and this is certainly one of them. We're expected to have those answers and guidance one way or the other. Fortunately, we do not have that guidance, and to the Senate, I apologize for that. Again, I will be voting no on this confirmation. Thank you.
Senator from Windsor.
Thank you, Mr. President. I'm disheartened by that last action of your committee, and I would ask the chair, if I may interrogate the chair of Senate
The chair
Judiciary.
is interrogated.
I guess at this moment, I'd ask, were your expectations going into that committee hearing, were your expectations that you were going to be having an up or down vote?
Senator, I would remind the senator from Windsor that we don't use you or your. You're asking
Thank you.
questions through the president.
Thank you. Again, I will repeat, were the senator's expectations that the committee vote that day would be an up or down vote?
My expectation was that there would be a conversation about whether or not a no recommendation was a good idea. It was general. The answer to your question is yes. I did expect that there would either be a yes or no vote, although I did expect that there would be a conversation about whether or not there should be no recommendation.
I would assume you would have had a conversation about all the options in front of you, one of them being, of course, a no recommendation. So I guess then I would follow up with the senator and ask, how did you feel about not having?
Senator,
How did the senator
I don't want to
feel?
continue to scold you, but please drop the yous and the yours.
Thank you, thank you. Very hard. He's right next to me.
I see that.
I would repeat that I would ask the senator how the senator felt about about not having that up or down vote.
I would describe it really the same way I described in the speech. I think that committees are expected to provide an up or down vote to the Senate.
And I think with that answer, Mr. President, I would move that we recommit this nomination to the Committee of Jurisdiction, the Senate Judiciary Committee.
The senator from Windsor has moved that the appointment of Michael Drescher be recommitted to the Committee on Judiciary. Senator from Chittenden.
Which is Chittenden?
Go ahead, Senator
Perhaps.
from Chittenden South.
Thank you. Thank you, Mr. President. Mr. President, what that brief exchange demonstrated to me is that this is a historic moment for us to be taking this vote. People want clarity, if they can have it, on how we come to this vote today. And I think we heard two very strong and compelling presentations from our chair of the Judiciary Committee. And Vermonters deserve to know that we have fully weighed the decision before us. What I heard in that interrogation, Mr. President, is that our very measured chair of the Senate Judiciary Committee took a lot of time and care in this process and then was not afforded the opportunity to take that time and care with the most consequential decision of all, whether or not to bring this vote to the floor without a recommendation. And so, Mr. President, I would ask for a brief recess, maybe a not so brief recess, so that we may discuss in a dignified manner things that are hard to discuss on the floor, which is the feelings of that the chair of the Judiciary Committee, who has made such a compelling presentation, and how we might approach the gravity of this vote. So with that, Mr. President, I would ask that we take a recess.
The Senate Secretary has informed me that that motion is in order. Could we set a time certain?
Mr. President, I would ask for a 20-minute recess, which is about, I do have my glasses on, is that 10:30?
The
But
Senate,
now making it clear, my time reading skills with this particular clock are not great.
the senator from Chittenden Southeast has moved that the Senate recess. I am going to say until 10:30.
Thank you, Mr. President.
Are you ready for the question? If so, all in favor, say aye.
Aye.
All those opposed, nay.
No.
The nays appear to have it. The nays do have it. A division has been requested. We will do a division. All in favor, please stand. Yes. You may be seated. All opposed, please stand. Please be seated. The ayes being 17 and the nays 13, we will stand in recess until 10:30.